Evening, everyone. Welcome to the National Liberal Club evening talk by Paul Scholey. Paul is the Senior Employment Law at a firm of employment lawyers and general lawyers who only work for trade unions, and he's a colleague of mine in my working life. I'm not going to say very much more than that, other than to say if you have questions, which Paul will take at the end, if you could put them in the chat box, but directed to Tim McNally rather than to everyone, and then I'll take them at the end. Paul, over to you.
Thanks, Val, and thanks, Tim, and thanks everybody for turning out on this spring Friday evening. We spend so much time online these days that it's nice to see people still prepared to come and listen after hours on a Friday. So I'm going to talk for just over half an hour probably, and I'll share my screen to get it cracking because I have some slides. If anybody would like a copy of the slides, then Tim has them, and I'm more than happy for him to share them. So let me see if I can make this work. Good, hopefully you can see a slide. So let's go. I've been doing this talk since about 2014 in one form or another, as social media has become increasingly ubiquitous, and it's hard to remember, I suppose, that, or easy to forget, that YouTube has only been with us since 2005. So back then it was practically a baby, but the issues that social media have created, and I suppose none more so than in recent elections in certain countries, are summed up pretty well, I think, by David Mitchell's remarks that I saw before I last delivered this talk, the nuclear weapons of the communications industry. So I'll start with a few statistics that I certainly find interesting, and I compared these when I updated them today to my 2014 figures for the same, and Facebook, it turned out, was at about 1.4 billion MAUs, monthly active users. So not the people who have lots and lots of separate accounts that sit there silently, but the people who participate on a regular basis are MAUs. And so Facebook has doubled in size from 2014 to early 21 and has a mere 1.84 billion visits per day by its users. Instagram's trebled in size from 400 million to nearly 1.2 billion at the end of last year. And YouTube, I didn't get a figure for 2014, but is now the second most popular social media vessel, with 2 billion monthly active users. And the most astonishing figure about them, I think, is the last one, that people watch more than 1 billion hours of video a day on YouTube. Somebody did the calculations who was better, I think, at maths than me, and suggested that that meant that everybody on earth was doing about 8 minutes, which is an astonishing figure. So it's not entirely surprising that when we commit so much time to social media, issues can arise legally in relation to it, and as a rule they arise in relation to Facebook, which will, I think, be the main topic of my talk this evening. Most users, or 30% at least, is the most common demographic, are 25 to 34 years of age, and the age demographic is increasing on Facebook, as many of you may have seen, but users aged 18 to 24 have dropped by 8% since 2012, and that drop continues as they move over increasingly to a picture-based Instagram or YouTube type channel. Slightly more than half of Facebook users are female, although the cases that we look at, I think, are probably more concerned with men losing it than women. Facebook gets 4 million likes a minute, and I find it interesting that the top posting time is 1 till 3 midweek, which I guess is when we've all had a bit of lunch at work and are fed up and don't really want to get back to it, so we spend some time posting nonsense to Facebook. And that's my favourite statistic, I think, that there are more social media users today than there were people in 1971. And as I've said, inevitably, as they begin to use these channels where it is so easy to hit the share button or the send button or the forward button, conflict is going to happen as between employees and their employers. And that's what I'll talk about in the time that follows. I'm a trade union lawyer by trade, have been for 30 years. I am unapologetically going to approach this from the point of view of the working person. So if it's biased, my apologies. Much of what I say, I'm afraid, will be not safe for work. I don't censor it. It'll be no surprise to any of you who spent more than about 3 minutes on Facebook that the language used there can be interesting, and that's one of the reasons, of course, that employers and employees come into conflict about it. I'll look at some of the cases which I think are probably the best guide for taking a view about how the law has developed in relation to the way it deals with what is a relatively new media, and I'll summarise it at the end with a view about how it has, in fact, if at all, changed the way that tribunals and courts operate. So I want to say, first of all, that usually what people do on Facebook is say something stupid and get sacked. And so a lot of the cases that you'll see in relation to social media are in fact employment tribunal unfair dismissal cases. And the law there, and I'm not going to go into detail about it because I don't want to get too technical, is set out in the 1996 Employment Rights Act. And it requires a tribunal to look at equity and the substantial merits of a case. There's an argument to say that the law's moved away from deciding whether a dismissal is unfair in determining whether it's an unfair dismissal, which sounds like an oxymoron, but in fact the law's becoming very technical, I think, over the last 25 years. And we have a test known as the band of reasonable responses, and I know that there's at least a lawyer or two and I think an employment judge amongst you, so I'll tread very carefully here. But from a claimant lawyer's point of view, an employee lawyer's point of view, this band creates an awful lot of difficulty for us. It means, in effect, that an employer can say, look, I was really harsh. But hey, other employers would have also taken a harsh view, and the available responses from one extreme to another were sufficiently wide, and mine fell within that band that my response was reasonable. And a lot of the cases address when an employer has gone too far and has fallen outside that band. And some of the cases are also very much concerned with whether the employers followed a fair procedure. And I hope you'll think that some of the cases we look at are unsurprising, and some are really quite surprising in terms of their outcome. I start with a really simple one, which should surprise nobody, a case called Gill and SAS Ground Services. As Gill was off sick from work for a number of weeks and chose to advertise on Facebook the fact that she was thoroughly enjoying getting involved with London Fashion Week and the catwalk, and her misconduct, of course, came to the attention of her employers, who dismissed her. And nothing changes in relation to that, as you'd expect. Whichever method of communication brings a matter of misconduct to the attention of an employer, the employer is entitled to act on it. But it's typical of the kind of anonymity or perhaps impunity that I think some employees feel that they have when they're facing a screen instead of perhaps a discussion in the pub or in the workplace. And some cases have been concerned with sharing by employees of confidential information. And there's one case in particular that I think is interesting in relation to that, called Xaver and the Dorchester, which concerns the well-known London Dorchester Hotel. Xaver was employed in the hotel's banqueting suite. The hotel, needless to say, had a confidentiality policy that was, to say the least, fairly fierce. But despite it, Xaver felt that the banqueting operational efficiencies, could be improved, and he tried to bring that to his employer's attention. Firstly via his manager, but when the manager wasn't listening, he took the thing to a blog, and began to record the management mistakes and communication failures and a number of disciplinary matters concerning HR investigations and the like. As a result of which, when his employers found out from no less a competitor hotel, who I'm sure took great delight in reading the stories of how the Dorchester was getting its banqueting wrong, he was suspended, disciplined and dismissed. He claimed unfair dismissal, and I think, again, unsurprisingly, the tribunal rejected that claim. It accepted, interestingly, that Zeber's intent was not malicious. He genuinely believed that he was helping the hotel, his employers, his colleagues, and the whole banqueting initiative by communicating the problems that he saw inherent in the way that the operation was conducted. But the tribunal was having none of it, took a very clear view that he was in breach of the clear confidentiality restrictions in his contract of employment, and the dismissal therefore was fair. One of the issues that tends to crop up, or that certainly employees think should crop up in relation to these cases, are the rights available under the Human Rights Act, which implements, as you will know, the European Convention on Human Rights into UK law, which remains at present part of UK law, notwithstanding Brexit. And claimants want to play in aid Articles 8 and 10 of the Convention, which are respect for private and family life and a respect for freedom of expression. And the first thing to say about both of those rights is that they are qualified, unlike, for example, the right to life, which is absolute. There is but a qualified right to privacy, and a qualified right to freedom of expression. So that tribunals find themselves conducting a balancing act between the privacy that an employee can reasonably expect and the obedience, if you like, that the employer can expect, and in particular the reputation that the employer might want to protect has to be set against the employee's freedom of expression. And my general sense of the cases over the years has been that, as a rule, the tribunals are not terribly interested in Human Rights Act rights in relation to these two aspects. And I think I understand that, and I think it's probably right, because I think the law of unfair dismissal gives tribunals the right to look at all these factors and to put them into the balance anyway. But there is one interesting case that's not actually a tribunal case, but a first instance High Court case. So it's not an appeal court decision, so make of it what you will, but it's an interesting case. I think by the name of Smith and Trafford Housing Trust. It's about 10 years old now. And Smith, and this was a Facebook case, Smith had a personal Facebook page where he described himself as a full-on charismatic Christian. And in the context of a number of postings by friends about gay marriage, he wrote, "This is an equality too far," and expanded on that when asked to say, no, he didn't approve of gay marriage. Marriage is for men and women. He said the state should not impose its rules on places of faith and conscience. The employer, being a housing trust, had a fairly extensive set of equality and diversity policies and took a dim view of Smith's postings. The policy said that nothing should be posted that might make another person feel uncomfortable, embarrassed or upset. Smith, it was said, had breached that policy, was suspended and found guilty of gross misconduct, and strangely was not in fact dismissed, but was demoted, and that resulted in a loss of salary of about £10,000 a year. So he pursued a claim for breach of contract in the High Court, and interestingly succeeded. And what the court said was that these postings firstly were personal, didn't appear to be related to work, so the section Article 8 rights in relation to privacy were in play. Secondly, and I think importantly, his expression of opinion was moderate. The court didn't think that it was capable of bringing the trust into disrepute because no one would think the worst of the trust for what was said. And I wonder whether 11 years later that would still be the case. That employees had widely differing religious and political beliefs, said the judge. And that, again, I think importantly, Smith was not proselytizing his beliefs so much as simply explaining a viewpoint. His freedom of expression in the context that I've described, said the judge, would trump the employer's insistence. In fact, his victory was entirely Pyrrhic. I think he recovered £100 in respect of his notice period, and I guess on the back of that we have an explanation for why the case never proceeded to an appeal. One of the few cases where human rights considerations have been forefront in the social media cases that I've been dealing with, and one that we still rely on from time to time if we want to push a privacy cum freedom of expression angle. Another High Court case was Mason and Huddersfield Giants. This was heard just over the road from our offices in Leeds, and Mason was a well-known player in the Huddersfield Giants, who each year at the end of season held a party that was described by the judge as a 2 or 3 day binge, when they drank pretty much solidly from Saturday until the following Tuesday. At the end of that period, whilst unconscious, one of Mason's colleagues acquired Mason's mobile phone and took a picture of an unmentionable part of his anatomy on the phone, and then put it back in Mason's pocket. And when Mason came to the following day, he found that his girlfriend had been looking at his phone and had found this picture. And one has to be straightforward about it. It was a picture of his anus. My favourite line in the judge's decision was when he said the picture is at page 320 of the bundle. And I can imagine in court everybody immediately paging through it to get to that or not. And the Mason's girlfriend posted this to Twitter, where he had 4,000 or 5,000 followers, saying, "What on earth is this?" Pretty quickly it was taken down. Mason said, when challenged about it by his employers, "I know nothing about it." But he was disciplined and dismissed, and brought a claim in the High Court, as you might expect for a sportsman on a reasonably lucrative contract, because the compensation he could recover in an employment tribunal would have been limited, whereas a breach of contract case in the High Court might have given him a jackpot recovery for the balance of his wages for a period of, say, 2 or 3 years, being the balance of his contract. The court was sympathetic and said he'd done nothing wrong at all, really. He hadn't been aware that the picture had been taken. He wasn't the one to share it, and upon finding out that it had been shared, he took it down. Accordingly, the club were in breach of contract, and he recovered substantial damages in relation to that breach. It's interesting to think whether that would have been different at all in an employment tribunal, where the employer might have argued, look, we accept he did nothing wrong, but a defence in an employment tribunal can be that there's nevertheless, despite the absence of any misconduct, that there's nevertheless some substantial reason, some other substantial reason it's called in the Employment Rights Act, for dismissal. So might the club have said, look, you did nothing wrong, but you brought us into such disrepute that we can't continue to keep you on side, because all these kids out there are complaining to their parents about what they're seeing in the Twitter sphere. I suspect that wouldn't have flown, in fact, because one of the things the judge did say was that Huddersfield Giants' defence in part was about the family atmosphere that they tried to cultivate in relation to their club. And the judge pointed out that that family atmosphere was not entirely consistent with the 3-day bender that the club encouraged on an annual basis. Another sporting case, and another High Court case, in fact, and the next couple of cases are about, I've talked about skeletons in the backup, about how ancient history and social media can come back to haunt one now. Williams was a senior exec at Leeds, under notice of redundancy by the club and expected to recover substantial monies in relation to that redundancy. A long notice period meant substantial money had to be paid to get rid of him. So to avoid that, in a pretty shocking, cheap show, even for my home club, the club brought in some forensic IT experts and said, find what dirt you can in his email account. And sure enough, they found a number of emails sent 5 years earlier that were said to be pornographic, and that, despite William's denial, were plainly in fact pornographic and had been sent to the manager of another well-known club, but more significantly to a young member of the admin team at Leeds. His point, of course, was there was no damage to reputation until you dug this thing out. There was no damage to anyone at all. There had been no complaints. I had an unblemished record. You're simply trying to find a way to save yourself 50,000 quid in relation to my redundancy. But the court was having none of it. It had not been found previously, said the judge. Once the club were aware that something had been sent that was wholly inappropriate and doubtless at the time could have led to dismissal, then the fact that 5 years had passed in the meantime was simply 5 years during which Williams had been lucky, and the skeleton came back to haunt him and he lost the case and recovered nothing. On a similar note, in a case from 2015 called British Waterways and Smith found himself facing a series of internal meetings in relation to a mediation called because he'd fallen out with his manager. And in the process, his manager had dug back through old social media posts, which included some remarks that Smith had made about whether or not he was having a drink whilst he was meant to be on duty in a safety critical role. Smith was dismissed, not in relation to the matters that were concerned, that the mediation concerned, but in relation to these 2-year-old posts that had emerged, and the tribunal had to consider whether it was permissible for the employer to rely on them, and as with Williams, the tribunal concluded that it was. That's a troublesome case to me, because the manager knew about the remarks that had been made 2 years previously and had simply done nothing about it. And when I've done this talk before, I've been approached on many occasions by trade union reps who say, what do I do if somebody comes to me and says that this is in my closet? Because if I go and tell HR about it, they might well sack me. And Smith doesn't give us any terribly useful ways to address that. The next cases are what I describe under the heading of letting off steam. A lot of the tribunal decisions that we see have to balance, as I've said, the needs of an employee to communicate privately and with freedom and in a way that enables them, after a hard and long day at work, to let off a certain amount of steam. And then there's the balance between that and the reputational damage that might be inflicted on an employer by remarks that go too far. So these are cases where remarks may or may not have gone too far. And I start with Dixon and GBI Limited. Mrs. Dixon raised a grievance about changes to her job on her return from maternity leave. But at the same time, her employers discovered that she'd been accessing her manager's email account and searching for emails relating to her. So she was suspended and a disciplinary procedure was instigated against her. And during her suspension, she posted to Facebook that she was not entirely happy with her employers, who were, she said, the biggest bunch of wankers known to the human race, full of gingers, sleazers, brown noses and cokeheads, which came to her employer's attention. And in fact, it never ceases to amaze me that it's Facebook friends who tend to report these things to one's employers. I think the moral of the story is be very careful who you admit onto your Facebook friend list. But the matter was eventually before a tribunal on an unfair dismissal claim, and the tribunal took the view, firstly, that accessing the manager's emails, as one might expect, rendered her dismissal fair, but that in fact the offensive and abusive Facebook postings were sufficiently serious to entitle a reasonable employer to dismiss on that ground alone. And I guess you can say with some of these cases, the more extreme ones are reasonably obvious, but there are quite a few, I think, that appear to be somewhere in the middle. Let me deal with Walters next, simply because that's the order of my notes. I do occasionally shop in Asda, but it's interesting to see that their employees are not always delighted with their employers. There were a number of Facebook groups that were set up, one called I Work in Asda and It Makes Me Want to Die, and the other was I Work in Asda and I Am Not Always Happy to Help. There was a policy introduced by Asda to deal with what it perceived as a growing problem with social media posts, and it set out in the policy a number of examples of the sort of thing that one ought not to say, including why are customers such wankers, and it made it clear that anything that damaged trust and confidence could result in disciplinary action. And it's an old case, 2007-8. Walters posted a comment on her Facebook page, and she said, I know I'm supposed to love my customers, but hitting them with a pickaxe would make me much happier. She denied at first that she was the author of the comment, but Asda didn't accept that denial, and they decided that she should be dismissed. The tribunal said that that dismissal was unfair. It accepted that she had in fact posted the messages and had tried to avoid the consequences of them, but, said the tribunal, this fell into the category of misconduct, not gross misconduct, and that she had, for example, long and exemplary service, and that ought to have been taken into account against what was an out of character and relatively innocuous remark, I suppose, unless you were one of the customers who'd been struck by the pickaxe. But even in these cases, what one finds is that understandably a tribunal will say, well, you might win, but we're going to recognise that perhaps you brought this upon yourself. And in her case, her compensation was reduced by a half because of contributory fault. In Whittam and Ventura, Whittam worked for Skoda, the car manufacturer, owned at that time by VW, and I still think it is. And after a difficult day at work, she posted on her Facebook page, I think I work in a nursery, and I do not mean working with plants. Lots of people on her Facebook page responded, and she said in relation to some of the encouragement she was given by them, don't worry, it takes a lot for the bastards to grind me down, LOL. Again, two of her Facebook friends, quote unquote, saw that exchange, reported it to management, and she was dismissed. And one of the things that the employer said was, look, we are here at the whim of Volkswagen, and the relationship between the two companies might be adversely affected by the sort of remarks that you're making. The tribunal said, we're not having it. The dismissal was unfair. They'd never asked VW what they actually thought about it. And more to the point, in fact, was it really likely that an international company the size of Volkswagen would be terribly upset by a relatively, again, innocuous remark made by one employee of Skoda? So the dismissal was unfair. In Weeks, this is the most literary, I think, of the Facebook cases that I've come across. Weeks posted over a period of time how working at Everything Everywhere was equivalent to working in Dante's Inferno. 12 hours, he said, in the Inferno dampen the spirit. Dante awaits me, he said, what a downer. And over a period of days continued to make these wonderful references, which in due course were reported by a friend to management on the basis that they might bring the company into disrepute. Management did not immediately sack, but said, please cease and desist. Weeks did not. His reply was, no fucker can tell me what to do in my personal life. And immediately a written note was sent to him saying, please sign this to confirm that you won't continue. The matter escalated again when then on Facebook he posted that he'd become aware of who it was who'd reported him to management in the first place, and he posted "eat cake, bitch." He was disciplined and sacked, and his unfair dismissal claim, I think unsurprisingly, failed. What the interesting part of it is this, I think, that once the thing had become threatening and potentially even violent towards the member of staff who'd reported him, I think his dismissal was inevitable. But interestingly, the tribunal also thought that his persistence with his Dante's Inferno remarks in and of itself might have justified dismissal. And the last case on this list is Gibbons and British Council. Gibbons worked for a non-departmental public body, registered charity called the British Council, and was well known by her colleagues as the Red under the bed. Lifelong Republican, and saw a Facebook post which was abusive towards a member of royalty who was a child, and said, in fact what was said was, "I know he's only 2 years old, but Prince George already looks like a fucking dickhead." And she made this comment: "White privilege. That cheeky grin is the already locked in innate knowledge that he's royal, rich, advantaged, and will never know any difficulties or hardships in life. Let's find photos of 3-year-old Syrian refugee children and see if they look alike, eh? And I'm sound in my socialist, atheist, and Republican opinions. I don't believe the royal family have any place in a modern democracy, least of all when they live on public money. That's privilege and it needs to end." The media got hold of this, and unfairly, she was tarred with the brush of the original comment that was directly and unpleasantly abusive towards a 2-year-old. And the employers accepted, in fact, that at all stages she was never responsible for that, didn't encourage it, and that her comments were of an entirely different character. But, said the employer, again, we have a social media policy that very clearly says you may not bring us into disrepute. And the tribunal found that her dismissal was fair. And it looks like a hard case, I think, in many ways, but the social media policy was detailed, extensive, and everybody had been trained about it. The organisation found it difficult to deal with a media that was created by the publicity on the back of her Facebook posting. And really interestingly, she included a claim for discrimination on the grounds of religion and belief, specifically her belief in a Republican state. And what the tribunal said is that would have been protected if you were dismissed for your Republican beliefs, but you weren't. You were dismissed because you enabled yourself and therefore the organisation to become associated with posts on Facebook that were beyond the pale. So, where does all that take us? Well, one of my firm's own cases, called Lake and Amy from 2015, interestingly had an employment judge say we're not prepared to set a set of rules that should be applied in social media cases, and then very helpfully went out and set out 7 or 8 that could reasonably be looked at in this type of case. But the bottom line is that factors such as, obviously, the seriousness and unpleasantness of the post that you make will be taken into account, whether there is any reputational damage and whether that is imagined by the employer or real and might really have affected customer relationships, say, whether the employee has apologized. And I certainly, in my advice, make a point of saying to any employee who says to me, "I'm in trouble, I put this on social media, what do?" I say, firstly, delete it, and secondly, apologize for it. And the cases do seem to go very much towards the people who take a reasonable view about remorse. And there we go. There are no particular special legal principles. So I conclude by saying that meet the new law same as the old law. The principles that have always applied will apply. The courts have a balancing act in which they're not, I think, hugely helped by the European Convention on Human Rights. The reality is that what I've seen over the last 20 years, I suppose, is that employees have found many more bigger and more serious opportunities to make a fool of themselves by hitting the send or share button before they should have. And if I can very quickly and in one slide plug this, I'd like to say it's a book. It's not. It's a report, more of a long pamphlet, really, written by one of my partners at Mauritius and I. The Institute of Employment Rights, as some of you may know, is a non-profit making organisation. I declare an interest. I sit on the executive of it, and it supports and develops employment rights for employees. And we've published this report that deals with all those cases and a bunch of other ones. If you're interested, and I encourage you to have a look, please, because all the proceeds go not to me, but to the Institute, and I think it's a very valuable service that they provide. And at about 35 minutes, that's it.
Oh, thanks, Paul. That's although I've heard it before, that's still refreshing to hear. We do have some questions, so I will go first to Janet Berridge, the first woman chairman of the National Liberal Club, who's and first our international guest because she's sat in Berlin. Janet.
Thank you very much, Val, and thank you, Paul. That was most interesting. I was thinking of something that I have noticed on Twitter more than once, which is that there's somebody, I can't remember the name of the name he uses, but there's a civil servant who has managed to remain anonymous, who seems to leak information out of what's happening behind the scenes. And similarly, there have been cases of NHS, National Health Service employees who also remain anonymous. And I suppose they both come into the category of whistleblowers. But I imagine that their employers aren't happy to see some of what they post, and perhaps it's not always entirely accurate. But how then, if an employer says, I'm not happy with what I'm seeing on social media, how do the lawyers find out who's behind something like that? And where is the line between someone being only offensive and someone bringing a very valid matter to the public's public awareness that needs, attention?
Thanks, Charlotte. That's a really interesting question, and it opens up a whole bunch of avenues I could talk about. I suppose the first thing to say is that the whistleblowing laws, the public interest disclosure laws, only protect employees who make their public interest disclosures in a certain way, and ordinarily that will mean internally, at least insofar as they can. And lots of employees think that they can go to the press or the public at large or social media, as you say. That will almost certainly never be the right way to do it, and the protection that the law affords a whistleblower therefore is unlikely to apply in those cases. That's the first thing to say. The second, and I'm not interested. I've never been involved in one, I think, but there are cases where employers have sought to get orders against the likes of Facebook or Twitter to say, we need you to reveal who it is behind the things that have been posted. And I'm not an expert on that, so I won't seek to comment on it. But I think that the social media giants take the view that they'll resist that by hook or by crook, so far as they can.
Right, thank you very much. I suppose really you say that an employee ought to have recourse within their work environment, but of course if it's something that reflects badly on the employer, they're going to try and bury it, aren't they? That's why people do go public on social media. Completely,
and ironically, of course, the more egregious the action of the employer, the less likely the employee is to want to put their head above the ramparts.
Yeah, absolutely. Well, thank you very much.
Okay, next we'll go to former judge, His Honour Charles Welshman. There we go, Charles. Charles, you're frozen. I'll come back to Charles because he seems to be having trouble with his connection. So we'll go another international guest, John Gulliver, is calling us from Maine in America. John.
Thank you, and thank you very much, Paul, for this really interesting presentation. I'm an attorney, though I don't practice in this area, so you've taught me a great deal. I wondered, under UK law, when can employers proactively examine an employee's social media account? For example, what happens in connection with a claim of harassment by a coworker? Do employers have either the right or the obligation to do so? And as you probably can guess from my question, in the United States, this is largely a question of state law, so we have 50 different variants of whether there's a right or an obligation or not.
Yeah, that's a good question and raises a lot of issues. The examination of social media accounts has become a hot topic in lots of ways.
Yeah.
One of the ways that, although your question didn't touch upon it, but it's worth mentioning it, is in relation to the vetting of new employees, where people's entire history can be trawled to find out if they've what I've described earlier as skeletons in the closet, which makes them perhaps a bad hire. In most of the cases that I mentioned today and that I've dealt with, that the social media posts that are central to the case have already been reported by somebody. And so the trawl's not really terribly important, because the so-called friends on Facebook have transmitted the thing onwards. And I think one of the reasons why tribunals and courts have been reluctant to give protection on the grounds of privacy is that the print screen button and the forward button and the copy and paste tools render it so simple to take a private message and to have it all over the world within 10 minutes. And several of the tribunal cases concern decisions about whether, say, a Facebook post has lost that quality of privacy or confidentiality simply because it's been so widely distributed. I don't know if that answers quite your question, but hopefully it talks to it.
I think it approaches the same problem from a different angle, and I was struck by the number of cases where it was another Facebook user who brought it to the attention of the employer, as opposed to the employer feeling somehow empowered to look at an employee's account sua sponte, or because another employee complained that XYZ is harassing me on Facebook or some other form of social media. So, well, thank you.
I'll come back on that if I may, because that's really interesting. One of the things I left out on of the talk, just because I think it went down an alley that would have taken me another hour, is surveillance at work, and that's something else that I've talked about for the last few years. And this question in particular of the extent to which an employer can monitor the private communications of an employee. And there's a well-known case called Barbulescu that was in one previous version of the slides I've done, which was decided by eventually the Grand Chamber of the European Court of Human Rights, which is very rarely gets together to make these really important decisions. And right up until that point, the employee had lost all along, despite the fact that his employer's actions had been atrocious. Very personal and intimate messages passing between him and his lover had not just been intercepted by the employer when they knew full well that these were personal and intimate, but then been distributed by the employer amongst their staff as a way to punish and embarrass him. And finally, the Grand Chamber, by I think a majority, in fact, took the view that the employers had acted in a pretty atrocious way, and that in that case his rights to privacy trumped the employer's rights to monitor. But there are lots and lots of cases in the UK that don't take that view. Most contracts of employment, for example, in the UK will, or most policies issued by employers will say, we reserve the right to monitor your communications from work. And the trade union movement, I know the TUC, for example, has been keen to try and say to employers, there should be at least some channel to enable people to make private use of social media at work, in the same way that most employers nowadays allow a private telephone call, at least from time to time. So there's I'll stop there because I could go on for hours about it, but it's a really interesting subject in its own right.
Thank you.
Thanks, both of you. I'll come next to Judge Tim Harrington, who's a regular at our Tuesday table in the club. Tim.
Yes, thank you, Val. I'll say, first of all, thank you very much for a very entertaining talk. It's nice to have lawyers who can make the subject extremely entertaining as well as informative. I hasten to say I'm not actually an employment judge, but I do hear cases where I have similar issues. One of my jurisdictions is to decide whether people are fit to work in the financial services industry, and sometimes their private behaviour as opposed to their behaviour at work is taken into account. And what struck me from what you said is that basically, if you are a user of social media, expect to give up that distinction between your private life and your employment life. It seems that the right to privacy under the ECHR is almost a vanishing point if you enter into social media in a way that can lead to issues that you're likely to come off worse by using social media than if you kept your opinionated views to talking to people in the National Liberal Club bar or in the pub. So is that, has affect social media made that distinction between your right to a private life and i.e. what you do outside work and what you do in the workplace rather more blurred than it used to be?
Yeah, absolutely. I mean, I think you've expressed it very well, and I think there's a reason for it, and I think that it's the difference between the ephemeral remark that might have been made at 6 o'clock on a Friday night when everybody popped down the pub for a few after work, and the cast iron black and white words that have been broadcast across the continents by virtue of email or Facebook or Twitter or whatever. And suddenly that thing that might not have even been remembered on the Monday morning, or if it was, perhaps the reliability of the memories of those concerned was not 100%. That ephemerality, I think, is where the thing has changed, and what social media has done, as we all, I would imagine at least most of us have come to regret at one time or another, has enabled us by a quick button press to commit something to everlasting memory that otherwise might have faded away quickly.
Yeah, and just one other supplementary, if I may. Your cases on letting off steam just got me thinking that sometimes employers have a bit of a sense of humour failure. Is that a fair point or not? Or are they getting rather too up themselves on some of these points? I
can say, because it's a public case, a public judgment. The case that I mentioned at the end, Lake and Amy, was a case where I encouraged my colleague in his tribunal submissions to use the words, "This is a corporate sense of humour failure." This is a man who took a picture of a yellow JCB type digger, which had collided with a fairly narrow 6 foot tall sign saying "Beware plant crossing," with a picture of a JCB digger on it, and was dismissed for it. And it was a shocking result in my view. We pursued it all the way to tribunal, and we won it. And he did use the words, "This was a corporate sense of humour failure," and I hope they assisted the tribunal coming to that decision. But there's a catch. He lost a quarter of his compensation because, said the tribunal, he contributed to his own downfall by posting the picture in the first place. But I absolutely agree. There are some of the cases, and I've omitted the ones that really I can't mention even in polite company. There are some of them where the language used is so awful that one isn't surprised. And one or two of the cases I've mentioned, I think, are of that sort. But there are plenty of them where a bit of common sense by management and a little bit less holier than thou, perhaps, would have meant that the thing could have been resolved with a slap on the wrist, or even a written warning or a final written warning. There's lots of ammunition available to a considerate employer short of the sack, said the trade union lawyer.
Thank you.
Thanks. Next up, Ben Riley.
Thanks, Val. I was wondering what your thoughts are on the Maya Forstater case, which it seems on the face of it to have some similarities thought about Republican views. I've been following this for professional reasons for years on Twitter, and so from the start I found this one quite interesting.
Sorry, I didn't catch which case.
Maya Forstater.
Not meaning anything to me, I'm afraid.
Oh, she's the one who was let go by the Tax Justice, Global Tax one, about things on Twitter about trans rights.
Sorry, I don't know enough about it to talk about it. I'm sorry. No, yeah, usually good at remembering principles, but case names escape me.
Okay, sorry about that. Chris Holworth.
Hi.
Hi, Chris.
Thanks very much. This is a question, quite straightforward question, I hope, but it's more about items that are factual and where the line is. So if
Chris, can I interrupt you? If you could get either closer to the mic or turn it up.
Oh, sorry. Any better, Val?
That's better. Thank you.
Sorry, so I'll start that again. This is a question about statements of fact, really. So where is the line if someone tweets or shares on their social media a statement of fact, such as, I voted for party name and the employer doesn't like that party, or if they share on social media an item of news that could be seen as an endorsement, but which is otherwise a sort of a factual thing. Does that make sense?
Yeah, that's a good question. Again, all of these questions could lead into huge discussions. I'll try and keep it the reply narrow, but some of the cases do involve exactly that sort of issue, where what's been said is neither rude, nor threatening, nor inaccurate, but where the employer says, nevertheless, it brings our reputation into question in the eyes of the public. So there's more than one case involving Apple, for example, whose social media policy and brand awareness policy is absolutely unbelievable, and requires that not only do you work for the company, but that in effect you worship at the altar of it on a daily basis, and in all your dealings with the public you will sell the benefits of Apple technology. And some of their cases concern remarks that don't appear to be either terribly wrong or unpleasant or whatever, but nevertheless representing Apple's view and interference with reputation that the employee has agreed already under a very long and detailed contract of employment to uphold. So that I don't think necessarily you escape by telling the truth, although obviously that will be a factor. The other issue is politics, and this is something that I wanted to do a piece of work about for a long time and have just not found the time, which is that certain large infrastructure companies, for example, who shall remain nameless, give very explicit instructions to their staff about what they can and can't say at election time, and the extent to which they can participate, for example, in, say, local elections. And I think there's a really interesting question there to be decided about freedom to express not an opinion that's horrible or threatening or unpleasant, but simply freedom to express a political opinion, and whether or not your employer can affect the way that you do it. Because one of the things that employers say in these cases is you're not simply making a private statement as a private individual. Paul Scholey on Facebook is not just Paul Scholey on Facebook, because if you look on my profile on Facebook on the left hand side, you'll see senior partner at Morris Listers in Leeds, also has got these jobs on XYZ boards. So because I choose to put that information there, I also choose, I suppose, to expose those organisations to risk because of what I say and whether or not that might be connected to their public-facing reputation. So I think that's really interesting.
We'll go to Adam Ali now, but can I just say we're running short time, so can you make questions short, please?
Sure. Good evening, Paul. Hi. Just a generic question. From the employer's perspective, what duty of care do we owe an employee if a complaint has come about them from the public that they've said something that isn't related to the protected characteristics, but it's still a complaint, like they've used bad language? Does an employer have a duty to inform the employee, and where is that line? Thank you.
Yeah, it's difficult. In terms of discrimination law, which is the easiest way to deal with it, we used to have a useful bit of law about third-party discrimination, where if an employer didn't protect, if you like, their employees from third parties, then action could be taken in relation to that. And the classic case was a case involving the so-called comedian Bernard Manning, who gave an after-dinner speech at which he abused BAME members of the waiting staff. But of course, he wasn't employed by the hotel that employed the waiting staff. And the legislation as was would give some protection there, but the Tories decided that we didn't need it. So we no longer have that, that protection from third-party discrimination. I still want to argue that in an appropriate case, a duty of care exists, not just in general employment law terms, but also in health and safety terms, to look after your employees and to prevent them becoming nervous wrecks because they're being attacked by the public. But I think it's a difficult area, and it's one where I'd like to see a return to the law as was.
Thanks. Over to Elaine Gadd now.
Thank you. One of the issues that concerns me is the abuse and threats on social media to women in public life. Often these are made anonymously, but I wondered if you are aware of any cases where a person has been identified, those abuse or threats have been drawn to the attention of an employer, and what the outcome was in such cases, and whether or not you feel that trying to tackle some of this abuse through identification and action with the employers might be a helpful way forward. Thank you.
Yeah, that's interesting. There are the cases that tend to come before, on me at least, and the tribunal cases that I've seen, tend to be where the abuse is as between co-employees, where a man employee abuses a woman employee, say, as opposed to, and I'm not sure if that's what you're touching on, the kind of more, and it seems to be very common, general abuse screamed at, say, female politicians, with anything that disagreed with leads to death threats and rape threats, it seems.
Exactly.
These days. I think by and large that's a matter for the police rather than employers necessarily, but it's a bigger thing than just the police. And I've increasingly come, and I hope it's not just age that's done that to me, but I've increasingly come from a view that said that social media was the be all and the end all and we needed complete freedom online, to a view that we have to regulate it now, actually, because the degree of unpleasantness and the degree to which it's proved possible for people like Trump to manipulate social media means, to my mind, that without some form of reasonable regulation, things will get a lot worse before they get any better.
Thanks. I'm going to try and go back to His Honour Charles Welshman, who's been in and out of my screen. So, Charles, over to you.
Well, I'm sorry, but well, I haven't really done justice to this this talk. Paul, thank you very much. It's been quite a revelation. I've been very suspicious about Facebook and have nothing to do with it. And what you said this evening really has reinforced that view. It does seem very harsh that when employers find out things they didn't know as a result of searches done after dismissal, that really can be held against an employee. I have the feeling that events have turned very much against employees over the years. I go back a long way. In my early years at the bar, I did do a little bit of work before what was then the Industrial Tribunal, and one got some quite good results on behalf of employees. But I feel now that the emphasis has changed, and it's much harder now for employees to succeed before a tribunal. But that's most probably your experience. I don't know, but you may have a long list of successes.
No, I agree with you, Judge. I think it's 30 years has seen, in my view, that the tables turned too far, and I would say that, wouldn't I, given the work that I do. But whilst employers complain sometimes that we can't do anything without being dragged off to a tribunal, what they do not see is the overwhelming number of cases referred to us that don't go anywhere, because our advice at the outset is they're not going to go anywhere because the law can't help you, and the law offers no remedy for you. In fact, in many cases, and in particular, the current one that I think about is the fire and rehire controversy that we're seeing discuss, the ability of an employer to say you're sacked today, but you can start again tomorrow on new terms, and because there's a new contract on the following day, there's no breach of contract. So again, that kind of thing is very frustrating for a lawyer trying to look after the employee, and unless a trade union is involved. And I apologise, I'm not here to advertise for unions, but unless a union is involved, then the playing field is anything but level for employees. The legal costs can be very substantial. It can easily cost 10, 15, 20,000 pounds to run a case to an employment tribunal if it runs all the way to a hearing. Unless you can get no win, no fee deals, or unless you're supported by a trade union, very difficult to go down that path. And representing oneself these days, hard, I think, in an area that's become, I think many would say, over-lawyered and over-technical.
Thanks, Paul. The other disadvantage, of course, is that there's a backlog in the employment tribunals at the moment. So it can be anything, certainly if you live in London, up to 2 years before you get a case into the court. That concludes our session, apart from it's handing over to Karen Ryszczak to give a vote of thanks from the club.
Thanks, Val. Thank you, Paul. I would like to express our sincere thanks to you for giving such an interesting, insightful and entertaining overview of social media and the law. Thank you also for making these slides available and for drawing our attention to the report from the Institute of Employment. You've provided us with some excellent case summaries which really demonstrate the pitfalls of social media for employees and employers alike. You've explained not only how skeletons can come back to haunt, but also how hijinks, letting off steam, as well as unfortunate postings can cause reputational damage and reputational risk. It appears send and share in most cases leads to delete and apologise. The statistic of 8 minutes a day of YouTube viewing per person will most certainly be exceeded by our members who will be viewing your excellent talk and fielding of questions on the NLC YouTube channel. Thank you again, Paul.
Thank you very much.
Thanks. Well done. Yeah. Thanks, Paul, and no doubt I will see you quite soon. That ends this. The next Women's Network event is on the 12th of April, when club member Dahlia Bond will tell us how she became an assistant professor. So do join us on YouTube, on Zoom for that. Okay, thank you.